Imagine spending years building a successful brand. You invest in product development, marketing, packaging, distribution, and customer trust. Your brand becomes valuable. Then one day you decide to enter the Chinese market. But when you check your trademark status, you discover something shocking. Someone else already owns your brand name in China. Not because they created the brand, not because they built the market, but because they registered the trademark first. In this video, I'll explain why foreign brands lose their names in China, how the Chinese trademark system works, and what you can do to protect your brand before it is too late. This is not a rare mistake. It happens to startups, e-commerce sellers, manufacturers, consumer brands, and even well-known international companies. Many foreign businesses assume that if they already own a trademark in their home country, or even in multiple countries, their brand is automatically protected in China. That assumption is dangerous, because trademark protection is territorial, and China has its own trademark system, its own filing rules, and its own commercial realities. If you enter the market too late, someone else may legally control the name you plan to use. The key concept you need to understand is this. China is a first-to-file trademark jurisdiction. That means, in most cases, the party who files the trademark first gets the legal priority. Not the company that used the brand first internationally, not the company that is more famous overseas, and not the company that deserves the name more. If another party files your brand name in China before you do, they may become the official trademark owner in China. And once that happens, your options become limited, expensive, and time-consuming. This is why foreign companies often feel shocked. They are thinking globally, but trademark law works country by country. So from a legal perspective, your global success does not automatically protect your position in China. The first major mistake is simple: filing too late. Many companies wait until they are ready to sell in China, or until they sign a distributor, or until they launch on e-commerce platforms. But by then, it may already be too late. In China, trademark strategy should start before market entry, not after. If your brand has commercial potential, it can attract early filings from unrelated third parties, competitors, distributors, or trademark squatters. The second major mistake is ignoring the Chinese version of the brand name. A lot of foreign companies only file their English brand name, but Chinese consumers often recognize brands by a Chinese name, whether that name is officially created by the company or informally created by the market. If you do not choose and register a Chinese name early, someone else may do it for you. And once the market adopts that name, it becomes much harder to control your brand identity. In practice, brand protection in China often requires protecting both the original foreign language name and the Chinese language name. The third mistake is filing in the wrong trademark classes. Some companies think they only need protection in one obvious class. But in China, the class strategy can be more nuanced. Depending on your business model, you may need to consider related product classes, service classes, defensive filings, and subclasses. If your filing scope is too narrow, another party may register the same or a similar name in an adjacent category, which can still create commercial confusion and legal risk. So trademark filing is not just about filing a name, it is also about filing the right name, in the right language, in the right classes, at the right time. So what should a foreign company do? Step 1. Run a proper trademark search before entering China. Do not assume your brand is available. Check whether your English name, logo, Chinese name, or similar versions have already been filed or registered. A trademark search can help you identify risks early before you invest in packaging, distribution, localization, or marketing. Because once a conflict appears after launch, the cost is much higher. Step 2. Build a China-specific trademark strategy. This usually means deciding which brand elements to protect, whether you need a Chinese brand name, which classes and subclasses to file in, whether you need broader defensive coverage, and how your trademark plan supports your market entry plan. In other words, do not treat trademark filing as an isolated legal formality. Treat it as part of your business strategy. Step 3. File early. If China is a serious market for your company, filing early is almost always cheaper than fixing problems later. The cost of prevention is usually small compared with the cost of opposition, invalidation, negotiation, rebranding, delayed market entry, or losing your preferred name. Early action creates options. Late action creates damage control. One important point many businesses underestimate is this: China trademark protection is not only about compliance, it is about commercial control. Your trademark affects distribution, online sales, licensing, enforcement, platform complaints, and long term brand value. If you do not control your name in China, you may face problems not only in law, but also in marketing, channel management, customer recognition, and business expansion. That is why smart companies do not ask, "Can we wait?" They ask, "What should we protect now?" before the market gets complicated. The earlier you think strategically, the more choices you keep. If your company is planning to enter China, sell to Chinese customers, manufacture in China, or protect a growing international brand, trademark planning should be one of your first legal steps. If this video was helpful, subscribe for more practical content about China trademark protection, IP risks, and doing business in China.